We are on the record in CR 2015-001671-001, 003, and 004, State of Arizona versus Gerald Bowman, Marcus Morris, and Markeith Morris. Ladies and gentlemen, before the break, I told you that our next step is closing. Before closings, I actually read to you the final jury instructions. He is passing out a copy of the final instructions. You are welcome to follow along, read, or just simply listen. Duty of jury. It is your duty as a juror to decide this case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You as jurors are the sole judges of what happened. You must consider all of these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. Lawyers' comments are not evidence. In their opening statements and closing arguments, the lawyers talk to you about the law and the evidence. What the lawyers say is not evidence, but it may help you to understand the law and the evidence. Evidence to be considered. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it in any answer given. Any testimony stricken from the court record must not be considered. Stipulations. The lawyers are permitted to stipulate that certain facts exist. This means that both sides agree those facts do exist and are part of the evidence. You are to treat a stipulation as any other evidence. You are free to accept it or reject it in whole or in part, just as any other evidence. Judicial notice of adjudicative facts. During the course of this trial, you were informed that the court has taken judicial notice of the day of the week of two particular calendar dates. You may or may not accept this judicial notice as conclusive. Presumption of innocence. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that a defendant is innocent. Burden of proof. The state has the burden of proving each defendant guilty beyond a reasonable doubt. This means that the state must prove each element of a charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of a defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that a defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. Jury not to consider penalty. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. Voluntariness of a defendant's statement. You must not consider any statements made by a defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statement voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to a defendant's statement as you feel it deserves under all the circumstances. Reduced exhibits. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Please do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Constitutional right not to testify. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that a defendant is likely to be guilty because a defendant did not testify. A defendant in a criminal case has a constitutional right to not testify at trial, and the exercise of that right cannot be considered by the jury in determining whether a defendant is guilty or not guilty. Evidence of any kind. The state must prove guilt beyond a reasonable doubt based on the evidence. A defendant is not required to produce evidence of any kind. A defendant's decision not to produce any evidence is not evidence of guilt. Defendant's testimony. If a defendant testified, you must evaluate that defendant's testimony the same as any other witness's testimony. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the test for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. Indictment is not evidence. The state has charged each defendant with certain crimes. A charge is not evidence against a defendant. You must not think that a defendant is guilty just because of a charge. Each defendant has pled not guilty. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise perceived an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence, regardless of whether it is direct or circumstantial. Testimony of law enforcement officers. Testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. Absence of other participant. The only matter for you to determine is whether the state has proved each defendant on trial in this case guilty beyond a reasonable doubt. A defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the alleged offense and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. The charged offenses. Each defendant is charged with committing 2 counts of aggravated assault. Count 1, aggravated assault. Each defendant is charged with committing aggravated assault. Aggravated assault, as alleged in count 1, requires proof that the defendant, 1, intentionally, knowingly, or recklessly caused physical injury to Eric Hood. And 2, the assault was aggravated by the following factor. The assault was committed by any means of force that caused a fracture to any body part of Eric Hood. Count 2, aggravated assault. Each defendant is charged with committing aggravated assault. Aggravated assault, as alleged in count 2, requires proof that 1, the defendant intentionally, knowingly, or recklessly caused physical injury to Eric Hood, and 2, the assault was aggravated by the following factor. The defendant committed the assault while Eric Hood's ability to resist was substantially impaired. Each defendant has pled not guilty to each charge. The state must prove each element of a charged crime beyond a reasonable doubt. Accomplice liability. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural, improbable, or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1. Solicits or commands another person to commit the offense. Or 2. Aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense. Or 3. Provides means or opportunity to another person to commit the offense. Mere presence. Guilt cannot be established by a defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that a defendant may have been present or knew that a crime was being committed does not in and of itself make a defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Separate counts. Each count charges a separate and distinct offense. You must decide each count separately on the evidence with the law applicable to it, uninfluenced by your decision on any other count. You may find that the state has proved beyond a reasonable doubt all, some, or none of the charged offenses. Your finding for each count must be stated in a separate verdict. Consider evidence separately. There are 3 defendants. You must consider the evidence in the case as a whole. However, you must consider the charges against each defendant separately. Each defendant is entitled to have the jury determine the verdict as to each of the crimes charged based upon that defendant's own conduct and from the evidence that applies to that defendant as if that defendant was tried alone. Each defendant's conduct may include acting as a principal or as an accomplice. Identification. The state must prove beyond a reasonable doubt that the in-court identification of a defendant at this trial is reliable. In determining whether an in-court identification is reliable, you may consider such things as 1. The witness's opportunity to view at the time of the crime. 2. The witness's degree of attention at the time of the crime. 3. The accuracy of any descriptions the witness made prior to the pretrial identification. 4. The witness's level of certainty at the time of the pretrial identification. 5. The time between the crime and the pretrial identification. And 6. Any other factor that affects the reliability of the identification. If you determine that the in-court identification of a defendant at this trial is not reliable, then you must not consider that identification. Alibi or non-presence of a defendant. The state has the burden of proving that a defendant was present at the time and place of the alleged crime was committed. If you have a reasonable doubt whether a defendant was present at the time and place the alleged crime was committed, you must find that defendant not guilty. Additional definitions. Definition with intentionally or with intent to. Intentionally or with intent to, as used in these instructions, means that a defendant's objective is to cause that result or to engage in that conduct. Definition of knowingly. Knowingly means that a defendant acted with awareness of or belief in the existence of conduct or circumstances constituting an offense. It does not mean that a defendant must have known the conduct is forbidden by law. Definition of physical injury. Physical injury means the impairment of physical condition. Definition of recklessly. Recklessly means that a defendant is aware of and consciously disregards a substantial and unjustifiable risk that conduct will result in physical injury. The risk must be of such nature and degree that disregarding it is a gross deviation from what a reasonable person would do in the situation. Included mental state knowingly. If the state is required to prove that a defendant acted knowingly, that requirement is satisfied if the state proves that a defendant acted intentionally. Included mental states recklessly. If the state is required to prove that a defendant acted recklessly, that requirement is satisfied if the state proves that a defendant acted intentionally or knowingly. Intent inference. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Jury foreperson. The case will soon be submitted to you for decision. When you go to the jury room, you will choose a foreperson. The role of foreperson is important, but please remember that the foreperson's opinion about the case is not more important than the other jurors. The opinions of each juror count equally. The foreperson's responsibilities include the following. 1, make sure every member of the jury is present during all discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussion should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the bailiff. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as the question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. Now, ladies and gentlemen, the last instruction is the closing instruction, and I read that to you after the lawyers have an opportunity to present their closing arguments.